and we will be your presenters today for Protect Yourself, why game designers need to know patents, copyrights, trademarks, and legal agreements. Now, before we get into the meat of today's discussion, we're lawyers, so we have to have a disclaimer. And there it is. I'm not going to read the whole thing. You don't have to read the whole thing. But in a nutshell, what it says is, yes, we are attorneys, but we are not your attorneys. So today's presentation is for informational purposes only. Nothing that we say should be considered formal legal advice. Even if we answer a direct question that you ask us, it's not legal advice. If after today's talk you think you might need formal legal assistance, we'll be happy to talk with you further. So with that having been said, what are we going to talk about today? So the way that we structured today's presentation is to sort of walk through the legal life cycle of game protection and game design. We're going to step through various stages of game design and what legal issues or areas of the law are relevant at those different steps. Okay. We'll also, yes, slides are working. Yes, good. We'll also talk a little bit about agreements that are relevant at various points and questions and answers. If at any point during today's presentation you have questions, please, jump in or put it in the chat, and we will address it, when we can, either during or after the presentation. And if any questions pop up afterwards, our email addresses are in the presentation as well. You can email us, and we're happy to answer them. So who are we? So I'm Sean. I'm a trademark and copyright attorney. I've been practicing since 2009. Gamer since birth, as noted there, and to this day, a repeated nemesis of Cthulhu and savior of Hyrule over and over and over again. That kingdom really just cannot get it together.
And I'm Dave Fitzgerald. I've been a patent and trademark attorney since 2008. I'm a patent attorney because I have a background in mechanical engineering in this case. So that's where I focus my patent practice. But on the trademark and licensing side, the majority of my clients are in this field, game designers and manufacturers and publishers. I am also a gamer since birth. A lot of tabletop games, as you see behind me here in the home office. Some very recent additions from Origins, and I'll probably refill that with some GenCon ones this weekend. But I spent a lot of my time earlier playing a lot more CCGs. Still am very much into Hearthstone. And as I put here on the bottom, I'm a Pokemon Go player to this day, Team Mystic forever, and on we go. So our firm is Wood, Herron Evans. We're located in Cincinnati, Ohio. We'll talk about a little bit later. That doesn't really matter so much as far as representing clients either nationwide in the US or worldwide, because intellectual property is really more of a nationwide practice than a state-by-state law practice. Our firm has been around for over 150 years. Sean and I have not been around for 150 years, but we've been around for part of it. We currently have about 35 attorneys, and all that we do is intellectual property. We used to have a picture of our building, which is the tall, narrow one hiding behind the white one on the left. But we are within a month of moving to new premises for the first time in about 90 years. So we're excited about our future, but regardless, we have a lot of professionals, and all we do is intellectual property law. That is the niche that we have carved out for ourselves. So that brings us to the game development lifecycle. This will be a slide that we come back to multiple times as we go through the talk. And basically, we go through step by step each part of the process as you're developing a game. There is at least one type of intellectual property that makes the most sense, or one type of legal agreement that makes the most sense to pick up at that stage. So the first thing you start with is the initial idea, and I'll let Sean take it from there.
Yeah, sure. So, a lot of times game design just starts with an idea, a concept, a flash of brilliance. And that idea can take a number of different forms. So it could be, social deduction, hidden trader game set in a high school social circle. So you have, a basic game design concept or basic mechanic in a particular setting. Or it might be something like Mansions of Madness meets Candyland. I would play that game. So you're sort of doing a mashup between two existing games. Game of Thrones deck builder with a companion augmented reality app. So we're talking about a game based on an existing property of some sort, Game of Thrones, but also, you might have some tech aspect to it, software, for example. So all of these are, ideas or concepts for a game. And at this early stage, when you just have an idea or a concept, really, the only way you could protect it is with an area of law called trade secret law. And as the name trade secret suggests, the idea is you have to keep something a secret. And if you do, you can then take steps to maintain that secrecy or go after someone if they try to disclose your secret. Okay, so early stages, you have a concept, keep it a secret. Okay, and how do you maintain secrecy? You want to share it with someone. Well, you can do that with contracts. You can do that with confidentiality or non-disclosure agreements. Sometimes you'll also see things called a non-commercialization agreement, or that'll be language in an NDA. And the idea is it's a legally binding agreement that someone else will sign, that essentially says, I'm going to share a secret with you. And in exchange for that, you agree that you're not going to share it with anybody else. Okay. Or you're only going to do limited things with that secret. Okay. And if someone violates that, if they disclose your trade secret when they've already signed an NDA, then you can either potentially take action against them for damages, or sometimes even a court can take steps to limit further exposure and sort of try to claw back the secret. It does work sometimes. And ultimately, trade secret law is useful throughout the game design process, particularly when you're dealing with things that you just don't want out in the open yet. You might be play testing. You might be working with other designers or other individuals who are helping you develop the game, but you don't want it to be widely distributed yet. Okay, so people always ask us, I have this great idea. How do I protect it? Well, this is how you protect just the idea. Okay, contracts and trade secret law. So if we move forward in the game design process, next you're probably going to start coming up with some rules, some functions. You're going to decide on some of the mechanics, perhaps, of your game. And that's where patent law comes in, and Dave is going to talk about that.
Yeah, so you're putting together either the game board and the core elements that you're putting together, or maybe the mechanics and the frameworks of what you put together. For functional things of that nature, as Sean said, patent law is the way that those are covered under intellectual property. So there are two types of patents we're going to talk about today as far as US patents. And the one that most people are familiar with is the utility patent. That's what we're talking about here. So utility patents cover useful functional inventions. And as I was just alluding to, this can be mechanics or rule sets, methods of playing a game, for example, or in modern times, things like app and board game implementations that work together, or unique components that work with a game or are a part of the game. And we have a couple examples of these from this year in a future slide. So the requirement for patents in the US and everywhere is that your invention must be novel and non-obvious over the prior art. Novelty is a bit of an easy hurdle. You just can't be exactly the same as something that is already out there previously. And non-obviousness is where the patent attorneys make all of their money, arguing over that gray area. Non-obviousness is an ordinary designer in the field could not have been able to take what is in the field and make combinations that would have rendered your invention obvious. It sounds like a gray area. It is kind of a gray area, but there is some standards and basically things that examiners at the patent office cannot do when combining art or stretching it too far. You could certainly make the argument sometimes that everything seems obvious if you make an argument to that effect. And in our field of game design, we do build on each other quite a bit. We take a lot of inspiration from prior designs. And in fact, sometimes we sell ourselves that way by saying, hey, do you know game X and Y? Well, my game is a combination of that. That might be great for marketing to customers. That is exactly the argument you don't want to have in front of a patent examiner at the patent office, because that is basically just making the case of obviousness for them. What does a patent get you? It is essentially the strongest form of IP we're going to talk about today. It is effectively a monopoly over the territory where you have it. So patents are country by country. If you have a United States patent, it will prevent any competitors from making, using, importing, selling, offering to sell, that whole list that you see there. You can envision it as really a fence or a monopoly around that pertinent country. So if you only have a US patent, you can't stop somebody from making a knockoff game or a copy game in China and selling it in Germany, which is a fact pattern that comes up a lot in this particular field. But if you have a German patent or a Chinese patent, you could stop that because you can stop either the manufacturer or the sale into that jurisdiction. So you really want to cover places, if you do pursue patents, you want to cover places that are either substantial sales markets for you or substantial manufacturing markets or places where your competitors operate. The term of utility patents is generally 20 years from the filing date. They don't last as long as the other forms of intellectual property we're going to talk about today because they are so strong. They are basically monopolies. The government doesn't really like giving out patents, but they do so that they can advance the sciences and the arts, or at least that's the policy theory, is that if they get people to put full disclosures of their inventions on the record, in the public record, then if we give them a few years or 2 decades of exclusive rights, then everybody else can learn from that disclosure and move forward from there. So a couple examples. These are more classic. Square Shooters is a game that we always have a sample of when we're in person. This is a set of poker dice. And you might be saying to yourself, 2011 is the date on this patent. Poker dice have been around for decades and decades. How is that something that is novel, let alone non-obvious? Well, what Square Shooters did, or the designers of Square Shooters did, is they did a bunch of math. They found all the permutations and combinations of the ways that you could apply 52 standard cards, as Sean was fiddling with earlier, and 2 jokers onto 9 six-sided dice. So there are 54 faces. You can only apply those 52 cards and the 2 jokers, 1 to each face. There is only one particular way that you can do that where the set of dice is capable of rolling every possible poker hand. And if you switch the 3 of clubs and the 10 of clubs on 2 of the dice, for example, you switch those 2 faces, there's at least one poker hand that you cannot roll anymore. I can't begin to fathom the amount of math that went into that to figure out that there was just this one combination. But indeed, it is true. And that was their sales pitch. So their sales pitch was, we are not just poker dice, but we are superior poker dice because we are the only poker dice that can roll every possible poker hand. That marketing shtick, ironically, in this case, is also exactly what proved that they were non-obvious to the patent office, and that's what got them the patent. So what does the patent cover? It covers just that particular set of poker dice. So if you were to make a set of poker dice and switch 2 of the faces, you fall outside the scope of this patent and they can't enforce against you. However, they don't really care about that because they think they have a superior product and they want to cover their niche on that superior product. So this is not a strange case, a rare case where the marketing spiel that they would tell you at the booth and the patent argument as to why it was patentable squared up very nicely. And then, of course, we've got Magic the Gathering, which created the entire CCG field or trading card game field. So Richard Garfield, when he was with Wizards of the Coast, was able to secure very broad patent protection. And they filed a few continuing follow-on cases that also pushed this into the digital realm. So they had coverage of card games or trading card games in digital spaces, as well as just your paper card game. And they had things covered so broadly as having a claim to turning a card 90 degrees to show that it had been used, which we all know is tapping in the game of Magic. But if you were around in the 90s in this field, you will remember that this was a super hot new field. Everybody was coming up with a card game or slapping an IP on a card game, and they were using every way you could think of to show that a card has been used other than turning a card, right? We were flipping cards over, we were covering cards, we were putting tokens on cards. They were doing that to avoid infringing the broad claim that Richard Garfield had acquired on the turning a card 90 degrees. That wasn't the only claim, but that was certainly the most famous and perhaps broadest claim that people had to work around. And the reason Richard Garfield was entitled to such broad claims is because he really did create a whole new branch of gaming. He really did do something truly innovative, and in those cases, you can get really strong and broad patent protection. And it was smart of them to cover it because it did force their competitors to kind of dance around the edges a little bit for a while. The Square Shooters patent is still active. The Magic patents, of course, are expired because they stem back to the 90s. That game is 30 years old or coming up on its 30th anniversary, I believe, next year. So all of the patents that were originally filed on Magic are now in the public domain, and anybody can copy those aspects of the game. And again, just to emphasize, we're talking the functional rules-based aspects. We're not talking about the creative content or the artwork or the name. Those are things we're going to talk about later. So a little bit newer examples from this year. I always go through the class where board games or tabletop games are classified, and I pull out a couple that catch my eye as interesting. The first one that you see at the top here is a bankruptcy board game. It is very politically themed. If you look at the spots on the board, I don't know if that's readable on this presentation, but it has spaces that are toddler tycoon and fake news and white collar cell block and tweets. So obviously very evocative of the former president, Donald Trump. And what was the political theme isn't what makes this game interesting or isn't what got it a patent. What got it a patent was the centerpiece that you see here had a spinner that essentially can angle upwardly and downwardly to vary how that spinner operates. So basically putting a little bit more leverage on certain spots on the wheel as you spin it. And then the integration of a scanner where it's a card-based movement game around the board. So all of that integration of the scanner with the cards and specifically how the spinner functions in the middle of the board, this unique component that's on their board, that's what they were able to secure patent protection on. So I think if this game becomes something that gets sold broadly, that would be the type of mechanic or the type of component that you could use in other settings, right? So they wouldn't have to necessarily be limited to this bankruptcy board game or this set of mechanics. They could take that spinner to some other company, integrate that in a different game design, and perhaps have good patent protection on that spinner. The other one that I pulled out from this year is a memory tic-tac-toe game, which of course strikes us as, well, that's crazy. That's the oldest game, one of the oldest games in the book. But it was the particular way that grid that you see, which is like a box-like grid, was constructed, and the fact that you're combining basically a memory guessing type game where you're covering or obfuscating whether you're putting X's or O's in certain spots with the standard tic-tac-toe gameplay. So their claims are covering a pretty specific rule set of combining these two types of gameplay. And the other claims that they have are very specific to the structure. So the grid work and how it sits on top of that box is recited in great detail. So in both cases, you can see there are things that you can patent, but they end up being very specific. So if you come to Sean and I, well, if you come to Sean, he's gonna direct your call to me immediately.
Yeah.
But if you come to us and say, hey, Sean and Dave, we're early on in the process and we want to file a patent, what do we need to do? The first reaction I'm probably going to tell you is, let's spend our money somewhere else. Because patents are quite expensive, as we'll get into in a second. They're very difficult to obtain, and quite frankly, the margins in this field of game design aren't where we can always justify the cost of pursuing a patent, which you may or may not get, and you don't get for a number of years. But if you do want to file, I will probably start with recommending to you a provisional patent application, and that gives you 1 year in which to market, further develop, get the game out there. You're locked in place relative to a filing date, but you're not having to draft a full set of claims. You don't have to have formalized drawings. You can cut down on a lot of the cost of preparing the application. It is a placeholder application, but it does lock in that priority date. And then within a year, you have to file the regular or non-provisional utility patent application. That's the one that actually does get picked up and reviewed by examiners at the patent office. And if it is granted, if it meets those hurdles of novelty and non-obviousness we talked about earlier, the patent will last 20 years from when you applied for it. Unfortunately, we have some pretty difficult case law that is making it even harder in the game design field to get patents. Uh, in fact, the 2016 decision I have for you there is one that I am highly critical of. It comes from the court level below the Supreme Court, but still an appeals court that covers the whole country. And it basically said that any card game you come up with that uses a standard deck of cards is an abstract idea and is ineligible for patent protection. No matter how sophisticated that rule set is, if you don't come up with a new deck of cards, it's not patentable. I strongly disagree with this position. I think game mechanics in and of themselves are patentable, and that seems to be proven time and time again when we look at modern examples of patents in this field. But nonetheless, if an examiner wanted to push the issue, they do have some case law behind them to say that this is an abstract idea. So I alluded to the high cost earlier. When do you want to do this? Well, unfortunately, with patents, if you don't file before you sell it or disclose it or otherwise put it in the public, you could lose the right to file. So you have to do that within a year in the US of that initial public disclosure or sale. So if you put something up on Kickstarter and disclose it to a good enough degree as you would on Kickstarter to get the sales or get the pre-orders, then that's going to start the clock. And if you don't file for a patent application within a year in the US, then you're going to be what's called barred from doing that. If you're interested in foreign patent protection, including in Germany, those grace periods are much less for the most part than the 1 year in the US. In Germany, for example, the grace period is 0. Now, what actually constitutes a public disclosure in Europe is a little less than the US, meaning our bar date triggers a little bit faster here, but we have a more generous grace period. Regardless, you're going to want to reach out to an attorney if you're interested in this as soon as you have the mechanics or the components designed, and certainly before you put it on the marketplace. The cost, the provisional that I talked about before, because you're not drafting claims, which is where attorneys, quite frankly, spend probably half their time on a patent application, and you're not having formalized patent drawings done, you can file a provisional application from anywhere from $2,500 to $6,500. All of the estimates that we're giving to you today are rough general estimates that are just kind of averages, and they're the ones that would involve you working with an attorney, just to be clear for the numbers that we give you today. When you go to a non-provisional application anymore, that's more like a $10,000 to $12,000 affair for the attorney work, the drawing work, the filing fee, and that's just the initial filing. The downstream process of fighting with the patent office to prove that to an examiner that your invention is patentable, and then the maintenance downstream if you do get it to issue the patents and maintain the patent, you could be looking at $25,000 or more over that 20-year term. So those dollar amounts are staggering and certainly have to be considered when deciding to enter the field of patents. Okay, so last thing with patents before we move on is some common mistakes that we see game designers or professionals in this field make. And it's not just game designers, this is kind of common mistakes that come up in every field. So the number one mistake that I've seen in 15 years of practice is that game designers or inventors, creative types assume that you have to have a patent in order to put your invention out there and practice it. That is absolutely not true. The patent is just a right to exclude others from competing with you. It is not a license to practice. And in fact, if you get your own patent, you could still be sued for infringement if you happen to infringe some earlier patent that has some underlying component that you've built on top of. So it is not a license to practice, and you can enter the field without ever touching the patent process. As I just alluded to, you do want to be a little careful in the one space that it might be worthwhile to spend a little bit of your money as you're doing the game design process is to do a clearance search and just make sure that there aren't any patents out there that are going to be problematic for you. That is the worst case scenario. Let's say you launch a successful Kickstarter, or God forbid you actually have stuff coming over from China on a boat. Then you get the cease and desist letter, and all of a sudden your your hard-earned boxes are either being secured at customs or potentially under an order to be destroyed, and you lose a lot of capital and a lot of market presence if that occurs. So don't ignore the fact that others might have patents, even though in this field it is kind of the least likely type of IP that you're going to run into. I think we already talked about the starting too soon. So that's obviously another mistake, is losing the right to file a patent by getting it out there too soon and not considering whether or not you wanted to file. And then we have a lot of IP that we're going to talk about today. Patents are one of the most complicated, so we spent a little bit of time to go over them in detail. But quite frankly, like I said earlier, if you come to me and say, hey, we're interested in a patent, more likely than not, I'm going to talk you out of it, which is not me talking myself out of work. I mean, it is to some extent. But what we want to do for you as counsel is guide you to the types of IP that are the best bang for your buck, that get you the protection that your business needs without overspending on intellectual property. So yes, patents are the strongest form of intellectual property. They are a monopoly in the countries where you get them, but they're very expensive. They're very hard to get, and is often a really strong case that a trademark, a copyright registration will serve you, and your business goals just as well. So then we move along finally in our game development life cycle to, okay, we've got the core, the underlying rules and functions built. Now we need to think about, what are we going to market ourselves as? What are we going to call the game? What is that look like? Because that is typically the next step of what you develop. And with regard to names, brands, what you're identifying yourself as, that's covered by a field of law called trademark. And here I'll pass it back over to Sean.
Yeah, so trademarks. Sometimes you'll also hear the phrase service marks. Also, we'll talk a little bit about trade dress, but they're all related, and all of this is talking about the name of a product or other aspects of your game that identify the source of the game. It's, oh, when I see that, I know that is Settlers of Catan, or it's part of the Settlers of Catan sort of empire of games, for example. Okay, the name of a game, the name of a company, logos, slogans, packaging elements, all of those things can serve as identifiers of the source of the game. Okay, so that's what we're talking about now under trademark law. And if you have a trademark, if you have protection over the name of your game, for example, then what you can do is you can prevent others from selling similar games with similar names. Okay, so again, if you have Settlers of Catan, for example, you might be able to stop someone from selling a game with a very similar name to that. Okay, and one of the nice things about trademarks is that unlike patent law, unlike patents, which at most can last for 20 years, trademarks can last potentially forever. There are some very famous trademarks out there, Coca-Cola, for example, that have been around for decades and decades. And as long as they're still selling Coke, they're going to have a trademark. Okay. Here are some examples of different things that can be trademarks on the next slide. So it can be a word or phrase like Settlers of Catan. It could be a logo. You might know that's Privateer Press. There's no wording there, but if you saw that, you might know, oh, that's a product from Privateer Press. It could be a character design. That, of course, is Mario from Nintendo. And trade dress, I mentioned, that refers to just the look of a product or its packaging. And for example, here we have the back of a card. I've blocked out the word mark on it, the wording, but we all know that that is Magic the Gathering. That's an example of their trade dress, is the look of the back of the card. So all of those things are forms of trademark or trade dress, and all of those aspects have protection. Now, how do you get protection over this stuff? Well, here's the good news as compared to patent law, okay? You don't actually have to file anything with the state or with the federal government. As soon as you start selling or providing your game out into the marketplace somehow, you will automatically start to develop what are called common law rights. In other words, they are unregistered trademark rights. You don't have to file anything, okay? And you're allowed to put the little TM symbol next to the name of your game, the name of your company, whatever, to the extent that you consider it to be one of your trademarks. There is, however, a registration option. If you sort of want, the maximum protection, the Cadillac of rights when it comes to trademarks, then that's where a federal trademark registration comes in. It's a registration with the U.S. Patent and Trademark Office. What are the benefits of having a registration? Well, number one, and most importantly, is it gives you a presumption of nationwide rights. If you're just relying on your common law or unregistered rights, initially you're just going to have rights where you are actually selling your product. So Dave and I, we're located here in Cincinnati. If we came out with a game and initially we were just selling, in and around Cincinnati, then that's where we would have rights. We wouldn't have rights in New York or Los Angeles, for example. But if you get a registration, that gives you a presumption, as I said, of nationwide rights, even if you're not selling yet in parts of the country, okay? It also gives you various presumptions of validity, exclusive ownership. It creates a public record, obviously, of your trademark. You can use the R in the circle symbol, which communicates that it is a registered trademark as opposed to an unregistered or common law trademark. And there are some additional benefits in terms of enforcement, things like that. There is typically some back and forth with the trademark office when you're doing a registration, but it's not nearly as onerous as a patent. So when to contact your friendly neighborhood trademark attorney. Ideally, you're going to do it pretty early in the process when you could still change the mark if you need to, okay? So why is that? Sort of like with a patent, the last thing that you want to do is come out with your game. You have a container full of games on their way over from the manufacturer in Asia, for example. You go to Kickstarter, you start releasing the game, and then you get the cease and desist letter, okay? That's the worst case scenario. So ideally, you're going to talk with an attorney. You're going to clear your mark very early in the process. If you're coming up with an original brand, so that's a new name that you've come up with, okay? Ideally, what you will do is you will clear the mark. We will do some searching, make sure that, yes, you can adopt this mark without getting into trouble with somebody else. No one else is going to sue you or send you a demand letter, okay? And if the mark appears clear, then you can file an application with the trademark office, potentially up to several years before you actually think you're going to get to market. And what that lets you do is it lets you reserve your rights to that trademark well in advance by filing that application. That's your line in the sand, sort of, that you establish, yes, I plan to use this trademark. If anyone else starts using that trademark after you, you could take action, okay? If during the search process, though, it looks like, boy, there really is risk here, you might not want to use this particular trademark that you've come up with, then we considered other trademarks, alternatives. We search those until we find something that appears clear and safe for you to use. Sometimes, though, you might not be coming up with an original trademark. You might want to use someone else's brand or trademark, a licensed property. So if we go all the way back, for example, to that one of the first slides, the Game of Thrones, for example, game. So that's a third-party trademark. You would want to get a license to use the trademark with your game. How do you do that? You approach the owner, whoever does own that trademark. Hopefully you negotiate a license agreement with terms that are acceptable to everyone. If you can't negotiate a license, well, then you need to look somewhere else. Consider on a different trademark to license, or consider coming up with your own trademark, okay? But either way, hopefully you can identify a trademark that you can use that is clear and that can be protected either by you or someone else, okay? So what are some common mistakes that we see? Well, number one, not clearing your trademark. Again, the worst thing you can do is really commit to a trademark, go to manufacturing, go to Kickstarter, and then you get the cease and desist letter. Okay, ideally, you clear your mark first, get an application filed first, and then you know that you're going to be safe. Okay. The other thing that we see is people, if they're going to pursue a trademark, remember, you can do it several years before you're going to get to market. Again, that allows you to reserve your rights. We often see people. We also see people who are relying on their unregistered rights, their common law rights, and they're not putting the TM symbol on their games. It's free. It's easy. Again, you don't have to register anything, but it's a simple thing you can do to communicate to other people. Hey, this is my brand. This is my trademark. Don't infringe upon it. Okay, and then the last major issue that we see is people not protecting their rights, not monitoring the industry, making sure that there aren't infringements out there, and taking action when appropriate. Because if you don't enforce and protect your trademark rights, then you can lose them over time. Okay. So Dave now has a pretty good cautionary tale when it comes to trademark rights.
Yeah, so an illustration of this in our field, or at least a somewhat related nerdy field, is the DC Comics versus DC Shoe Company conflict that happened almost a decade ago now. So DC Comics, of course, just like Marvel, is experiencing a renaissance both with movies and in every form of sales that they could have from comic books and beyond. And these are the two logos that, if you grew up with DC comics, you would be familiar with. The first logo, the circle around the letters DC with the stars, was used for almost 30 years, from 77 to 2005. And then they did stylize it a little bit. They rebranded themselves and became more of a stylized circle with a star on it, but still the same core design elements to their logo for DC was used from 2005 to 2012. And when they rebranded in the 2000s, they started paying a little bit more attention to what else was out there in the field. And someone at DC Comics internally noticed that DC Shoe Company had been using this letters DC with a star logo as well. And they thought, well, when I compare these two things, they're too close. And I'm not happy with this because while DC Comics is originally in the comic book field and makes creative content like movies, for example, they also span out and sell a lot of branded goods in places like apparel, right? They sell kids' shoes that have Superman or Batman on them. And because of this, there is an overlap of goods where there could be a trademark conflict. So the caution here is DC Comics basically rushed right into court rather than having an initial discourse. I put up for you since before 1977. And that makes them what's called the senior user. And that gives them the rights to tell DC Comics that they have to change their mark, which is the exact opposite of why DC Comics rushed into court to sue and try to shut down the use of this mark by DC Shoe Company. So it was probably the most gratifying thing ever for DC Shoe Company and its legal counsel to be able to not just say, no, we're not going to change our mark, but screw you, you're going to change your mark completely and go away from 30 years of your own branding. And what that led to, of course, was then DC Comics rebranded to go away from the circle and the star that had really been their brand identity at this point for almost 40 years. Ironically, they did try to market this by saying, hey, we're turning the page forward, and I hope that they turn the page forward on their legal counsel or whoever made the internal decision to rush right into court rather than perhaps just make a phone call and talk this out with DC Shoe Company. So 2 points. One, there's a lot of times when you can resolve a conflict outside the courts. And in fact, sometimes it turns out that, like in this case, you would be much better off just peacefully coexisting if you do a little bit of research or a little bit of discourse with the other side, because it turns out you might not win, even if you think you have the right claim. But then secondly, this goes back to Sean's recommendation earlier of clearing your marks. And when we're back in the 70s, I don't know that DC Comics was very invested into the apparel field, but certainly as they expanded over time into more and more fields and became a more and more popular brand, they should have continued to clear their use of their logos and their names in the fields that they were entering. And if they had done so, they might have noticed that this was a potential conflict much sooner, at which point maybe it could have come to a much more amicable resolution. So, there's one other, actually, sorry, I'll go back to the previous slide. One other quick example that I'll give you of clearing and registering your marks. We represented a company, Artana, who is now part of Genius Games. We represented their game designer when he was making the Tesla vs. Edison line of tabletop games. And we registered that that name for their line of games, Tesla v Edison. And even though it's not explicitly trademark rights, it's very similar. Public figures and celebrities, when they pass away, have a right of publicity that, depending on what state they pass away in, can last for many years, sometimes many decades. And that gives the estate the right to control their name and image, basically their likeness, in marketing contexts and fields. And in this case, the Edison estate did come after our game designer because Edison, you'll notice, is in Ford and GM and Coca-Cola ads, right? They market his image to big companies and big, six-figure advertising campaigns, because the image of Edison, whether or not you think he was a good guy as compared to Tesla or any other inventor, he is kind of associated with innovation and being inventive. So they put his image, and other companies put his image or his name in their marketing materials and in their advertising, and they pay the Edison estate for the right to use those images. Because we had registered for Tesla v Edison, we didn't clear that name against Edison's marks. They were making the claim that really they should own the trademark and that we didn't have a right to use it in commerce. That case did end amicably because, unlike DC Comics and DC Shoe Company, we didn't go to court right away. The lawyers talked to one another, and we came up with a license agreement where effectively the Edison estate owns the trademark, but they license it back to the board game company to use it. And in fact, they hit it off so well, meaning the principals, the game designer, and the Edison estate folks, that he went up there, our game designer went up there for a tour. They sell the game in their gift shop. If you go up to Edison's estate, you can find their games in the gift shop. So it turns out to be a really positive story at the end of the day, despite the fact that it was, again, one of these cases where if the client had wanted to spend the money to clear the mark, we would have perhaps seen this issue before filing and then causing the potential conflict. Okay, so let's move on in our game development lifecycle. Now we're going to get to the creative content, as I like to call it. Let's stick on the things that are the pizzazz, the sales points. You've got the underlying rules and functions and the idea built. You figured out what you're going to call yourself, and now you're coming up with the artwork and the text, whether it's on the cards or a board. You're coming up with the rules and writing out that rule set. This type of artwork and content is all covered by copyright law. And this is an area of law that I keep a nice 10-foot distance from generally. So I will pass it back to Sean for this.
Yeah, so copyright law. So we're talking about all of the creative aspects of your game, as Dave mentioned: artwork, text, sculptural items, minifigs, that sort of thing. If we're talking about a digital product, we're talking about the underlying software code. All of these things have creative authorship or content, and copyright law is the area of law that protects it. Okay. Now, what copyright law does not protect, as I emphasized there on the slide, are underlying ideas or concepts. Again, that's trade secret law. It doesn't protect mechanics. That's patent law. And there can be some overlap with trademark and trade dress, but for the most part, we're just talking about copyright at this point. Okay, and I'm going to have a couple slides here that show the difference between creative expression that is protected and the ideas or concepts that are not here in a moment. Okay, but if you have protection, if you have copyright protection over your creative content, again, your artwork, your text, whatever, then that allows you to prevent others from copying that work. Copyright, it's your right to control or limit copying. It also allows you to prevent other people from creating derivative works, that is, new works that are based on your creative content. Okay, and another nice thing about copyright, similar to trademark law, is that you don't have to register anything with the federal government or anyone to have a basic level of rights. As soon as you take your your idea, your creative, idea out of your head, and you fix it in the world somehow. You paint it on a canvas, draw it on a pad of paper, type it into your computer, sculpt it, on a wheel, whatever. Okay. As soon as you fix your creative expression in the world somehow, then you automatically receive a basic level of copyrights. Okay. And another nice thing about copyright, again, sort of more similar to trademarks versus patents, is that they last a very, very long time. Copyrights for works that are created today will last for your lifetime plus 70 years after that. So we'll all be dead by the time that any of your copyrights would ever expire. Okay. So very, very long time. So here's the example that I mentioned a moment ago about creative expression versus ideas or concepts. So everyone's familiar with the classic, casual game, Apples to Apples. Everyone is also probably very familiar with Cards Against Humanity. Now, mechanically, it's the exact same game. The concept as to how you play it, exactly the same. Okay, but Apples to Apples never had a patent over its rule set, its mechanics, that sort of thing. So anyone is allowed to copy that idea, that concept, and those basic mechanics and rules, okay, which is what Cards Against Humanity did. What Cards Against Humanity didn't do is copy any of the creative expression in Apples to Apples. It didn't copy the artwork on the box. It didn't copy the actual words that are on the decks of cards in the game. Cards Against Humanity came up with all of that creative expression itself originally. So did they copy some stuff from Apples to Apples? Yes, but the stuff they were allowed to copy was stuff that wasn't protected by copyright law. Now, and indeed, the same thing has now happened to Cards Against Humanity, as we've all seen, various other things come out. For example, Crabs Adjust Humidity. There's now Kids Against Maturity. There's sort of a whole cottage industry of, these types of games that have popped up. And again, because none of them are copying the expression of Cards Against Humanity or Apples to Apples, they're allowed to exist. It's not copyright infringement, though, as noted there on the screen, there was actually a trademark dispute between Cards Against Humanity and Crabs Adjust Humidity due to the similarity of the names of the brands. So again, much like trademark law, you don't need a registration, but you can get a registration for your copyright, for your authorship, for your creative work. Okay, again, similar to trademark law, there are a number of benefits: presumptions of validity, presumptions that you're the owner, you're the author of the work. But most importantly, having a federal copyright registration is necessary to actually take action against someone in court. It's sort of like your Wonka's golden ticket into court if you ever actually did have to sue someone for ripping you off, for copying your works without permission. If you have a registration in place, you can also get access to better monetary remedies if you did have to enforce, and you can work with U.S. Customs and Border Patrol if there are knockoffs coming in, for example, from overseas of your game. Then Customs will seize those products and ship them, send them back, or destroy them. Another nice thing about copyright registration is that they're comparatively inexpensive. Patents, super expensive, potentially tens of thousands of dollars. Trademarks, trademark registration, start to finish, you're looking at, perhaps $1,500. Okay, copyright registration, as low as $600. That's if you're working with an attorney. If you do a registration yourself, you're probably just going to have to pay about $50, $60 in filing fees. And again, for the level of protection that you get, it's a pretty good deal. It's a comparative bargain. Okay, when, again, to call your friendly neighborhood copyright attorney. So there are a few reasons why you might want to talk with an attorney regarding your copyrights. If you're hiring someone to create content for you, an artist, for example, or an author, okay, then you want to make sure that at the end of the day, you own that stuff that they're creating for you. And most people think that, oh, if I'm paying someone, then I'm automatically going to own it. That's not the case. You actually need a written agreement in most cases to transfer ownership over to you. So that'd be a development agreement or an artist agreement, something like that. Okay. If you want to use someone else's content, then an attorney can help you with that as well. You might need to get a license, like what we talked about with trademarks. But there are also limited situations in which you actually can use other people's content, or at least portions of it, without permission. It's called fair use. Copyright fair use is a pretty complicated topic. We really don't have time to get into the nuts and bolts of it today, but it is an option. When your game is basically complete, you're about to go to market, or maybe you have just started going to market. That's when you would potentially file a copyright application. Unlike trademarks, where you can do it well in advance. Same thing with patents. With copyrights, you really wait until you have all the finished stuff ready. Then you submit it all to the copyright office. Okay. The last reason you might need to talk with a copyright attorney is if someone's ripping you off, or if you get a demand letter, something like that. Okay, because obviously an attorney can help you either defend or enforce your rights. Common mistakes that we often see is people not putting a copyright notice on their games. Again, whether you have a registration or not, it doesn't matter. You're allowed to put a copyright notice on your game. There on the slide, that is a complete and sort of best practices copyright notice. The word copyright, the circle C symbol, the year of publication or creation if you haven't published your game yet, and then your name or the name of your company if you're doing this through a company. Okay, again, free, easy, and it just alerts people to the fact that you claim copyright over that content. Another issue that we see is people pursuing a federal registration after after you're already being ripped off. Can you get a registration then and sue? Yes, you can. However, your potential remedies aren't going to be as good. People also occasionally ask us about poor man's copyrights. If I take my game and I seal it in an envelope and then I mail it to myself, does that get me some additional protection? We've also heard various things like that over the years. The short answer is that's not a thing. Maybe it was a thing years ago, but it's not a thing under current law. You either don't have a registration or you get a registration. Those are really your two main options when it comes to protecting your rights. Concerning what you can and can't use from other people, that's again the fair use concept that I mentioned earlier. But the other thing that you can consider is works that are in the public domain. That's works that either never were protected by copyright or were protected by copyright at one time, and the copyrights have expired. There is a huge amount of content out there that is now in the public domain. All of the H.P. Lovecraft original stories, for example, all of that is in public domain. That's why, frankly, there's so much. It's one of the reasons why there's so much Lovecraftian content out there, is because no one needs to get a license for any of those original works. Alice in Wonderland would be another example. So considering what is out there that is free to use, that you can build upon. And then finally, not owning what you commission, not owning what you actually hire someone to create for you. As I said, typically you need a written agreement to transfer that ownership. Okay.
And I'll just interject that the Winnie the Pooh slasher movie that came out this summer is an exact reason, or an exact further example of this, meaning the original Winnie the Pooh book and the underlying copyright is now old enough that is in the public domain. But you will not see ER in that because ER came a few years later. So it can be complicated when trying to determine what you can use from the public domain and what you can't. But you see examples of this all the time, as Sean mentioned. Another way that we can cover creative type content is the other type of patent that I was alluding to earlier, and these are design patents. So rather than covering the functional or utility aspects, they cover aesthetics or ornamentality of a product. Design patents in the rest of the world are actually just design registrations, and they're covered much more like trademarks or trade dress. However, in the US, since that's where we practice, that's what we talk about mostly here, these are covered under the patent regime and the patent rules. However, instead of the utility patent where it's a lot of words and the claims are all in word description, a design patent is mostly just the figures, mostly just the drawings, because the claims of a design patent are just covering how it looks from every angle. So if you open up a design patent online, what you will see is just a series of figures showing a product from every angle, from a perspective view and top side view, so that you can understand exactly what's covered, what ornamentality is covered. So some examples from this year in this field are on the right-hand side, you've got a princess or queen-like playing piece. That is a playing piece that someone has claimed that is unique creative content or ornamentality, and they have a design patent on, in this case, they covered their game board and various game pieces. But if you bring out an identical princess meeple or game piece, you would run the risk of infringing this design patent. Same deal with the boards that you see on the left and in the center. If you were to copy the ornamentality, the way that these boards appear, rather than how they function, then you would run the risk of infringing this design patent. So unlike utility patents, these are quite a bit less expensive to obtain. They don't last quite as long. They last 15 years from the issue date, but they're another basically tool in the toolbox that we can use. And as I mentioned before, the cost, it's mostly in the drawings, and the patent office in the US is pretty particular because those drawings define what the scope of protection is for a design patent. You have to meet a lot of formal requirements. And like I said, they're pretty picky, so it helps to work with an engineer or a draftsman like we have in our office to put together those patent drawings. But all told, even with the filing fee, the design application is going to cost you a couple $1,000s up to maybe 5,000 if you have a lot of different embodiments, so you're covering a lot of different pieces in a game board, as I showed you a minute ago. It is, because it is a patent in the US, it gives you that same monopoly type rights or a fence around the country where you have that design patent. However, what you're covering, of course, is different. We're in a different part of our game design life cycle, and it's much more overlapping with what you could cover with trade dress and copyright protection and registration, rather than the utility patents we talked about before. Before we move on, let me see if I can do this successfully. So are we back on camera now? Just to confirm.
Yeah.
Okay. So this game right here is Scraps Golf. And it is, if you can see inside the packaging, a 9-sided die that what you can't see on camera is that it is dimpled like a golf ball. So it's a 9-sided die with dimples that looks like a golf ball. We were able to secure a design patent on this 9-sided die that looks like a golf ball, because the ornamentality of that, how it functions as a dice, is of course not new or not obvious, but the look of it is new and was important to this game designer. So that was a place where the game designer comes to me and says, how can we cover this in the best way possible? We got a design patent on that. We trademarked the name Scraps Golf as well. You could have also registered a copyright both on the art on the packaging and the game rules that are included on the back and inside this packaging. But regardless, this is a good example of a product coming to us advising on all the different ways that you could cover it. But it's also a really good example of design patents, because sometimes people have a little difficulty understanding where that fits in. So, okay, now we should be back on screen. Let's move on to the next part of our game development lifecycle, and that is production. So now you've put all the pieces together and you're ready to bring this thing to market. What do you have to worry about at this point? Well, we've kind of talked about all of the major branches of IP at this point and what you could secure yourself. So at this point, what you need to do before you hit the marketplace is make sure that all of the intellectual property rights, either owned by you or owned by people that you worked with, have been sorted out contractually or otherwise. So in the case of artwork that we talked about under the copyright section, you want to make sure that your license or your assignment of those copyrighted materials is effective, and you do have the right to enter the marketplace with those materials that weren't created by you. If you licensed a brand, for example, a Game of Thrones or some other existing intellectual property and brand that you're using to identify your game product or distinguish your game product in the field, you want to make sure that that license is done and effective. And again, you have the right to enter the marketplace with someone else's intellectual property. Same deal for your own intellectual property. This is kind of the last step or the last gate point before you enter the marketplace where you can secure all of your rights in the best way possible. As we talked about before, with copyright registrations and trademark registrations, there's no bar, so you can always file for those after the fact, but the set of rights that you might get might be a little bit less if you wait until you're knocked off, as opposed to doing it at this point when you're entering production. So the other thing you need to worry about is, of course, other contracts, which can involve, if you're working with a publisher, you'll have some form of contract called a publishing agreement. This will set forth all of the terms by which you're working with one another, what the publisher is doing as far as their obligations to put it into the marketplace and what timing to put it in the marketplace, what compensation that you get and when you get that compensation. And then perhaps most importantly and most overlooked is who owns the rights moving forward, and does the publisher have a right of first refusal or just outright the rights to publish any future projects or expansions. All of those things can be roped into a pretty big contract called a publishing agreement, and you want to make sure that that legal document is how you want it to read and it's in place before you actually hit production, so that way if things go wrong, then it's outlined in the contract what obligations the parties owe to one another, and how you would have the right to enforce that if, in this case, in this hypothetical, your publisher is not doing what they agreed to do. If you're self-publishing, unfortunately, this one publishing agreement document typically turns into, let's say, somewhere between 3 and 17 other agreements and documents that you're going to have to worry about. Because if you self-publish, of course, you're going to have to work with retailers and or distributors to put your game out there in the marketplace. So there might be separate agreements with each of those companies that you're using. And same deal with any production or manufacturer that you're dealing with. You're also going to have separate legal agreements with them. And each of these is a different kind of contract. They're all going to be unique to the deal that has been made. But it is definitely something that attorneys, and not just intellectual property attorneys, but attorneys can help you with. The place where intellectual property comes into this, though, is that describing the ownership, describing exactly the rights with regard to the intellectual property. Those are important terms in these contracts. And so that's why we often get involved, is even though attorneys generally can handle such types of commercial contracts, the intellectual property parts of them often are not done right if they're not done with either an intellectual property attorney as part of the team or as the attorney handling the agreement. So we don't give a lot more detail on this. We used to try to go through all the different types of legal agreements you might run into in this field. That again is kind of outside the scope of what we can cover with the time period that we have today. But just know that this is the time when you got to get all of your legal writings, all of your contracts in order before you hit the marketplace. Okay. So then you've produced the game, it's finally here, and you're ready to put it on store shelves or ready to put it in your booth at the exhibit hall and release it. What steps do you need to take at this point? Well, of course, now you're turning full into business marketing mode. You're promoting your game, but on the intellectual property side, as we talked about before, you're going to want to make sure that other folks are not, other designers and other competitors are not infringing on your rights. And in the case of trademark, for example, or trade dress, if you don't actively police your rights, you could over time lose those rights. So it becomes important even after you initially release to keep a monitor on the field and make sure that any rights that you have are enforced. You might have obligations from those contracts we just talked about to enforce against someone that knocks off your artwork, right? Even though the artist owns the copyright, it could be in that contract that you have some obligation to either inform them or enforce on behalf of them. You'll also, of course, referring back to those contracts, want to make sure that everybody is playing fair, playing by the rules of the deals that you made, whether that's the distributor or whether that's a game publisher. You know, if they're paying you not on time, you know, you need to bring that up and make sure that they're complying with the contract. And same deal, you need to comply with the contracts that you made. So make sure that you're not making any missteps relative to those legal agreements as well. And then in a perfect world, you move on to expansion. So the game has gone so well that you're bringing out supplemental content or a new version of the game as an expansion. And if you go back to that previous slide, essentially you're just repeating all of the same steps over again. So you might be coming up with a new set of rules or a new set of add-on functions. You might be, in fact, coming up with a new name, and you're certainly going to have new artwork and new content. All of those things, again, can be covered by new filings if you want to cover your expansion content. But you also need to be sensitive that all of that new content might then create more risk for infringing other people's intellectual property, even if your base game or your earlier versions were fine before. Sometimes you can run afoul of other people's IP at the expansion stage. So you just basically repeat all of the things we talked about before, but this is where you're leveraging the good marketing that you did before, the good design and development that you did before, and if you had any intellectual property, you're leveraging that so that you continue the revenue stream through multiple releases, commercial releases. And again, that's where some of this intellectual property that lasts for many, many years can be quite profitable as a business asset because it protects your place in the market. Okay. When we're in person, we hand out an intellectual property worksheet, and we have a one-page or a two-page version of this. So again, temporarily, I'll pull down the screen so you can see my camera a little bit bigger. All this document is a document that lays out for our particular field the various categories that we've talked about today, the functional elements, source identifiers, branding, so on and so forth, and then lists in each of these fields a number of the things that typically come up in this space. So when we talked about source identifiers and branding, it could be the company name, the company logo, the game name, the game series name. All of those are fields that we've populated in this worksheet. And we hand this out when we go to conventions because we find that some people want a quick reference guide or just a place where they can organize their notes. Because, of course, when you go to talk to an attorney, you're going to want to be able to give them the information so that they can properly advise you on what forms of intellectual property or what types of contracts you need to be spending your hard-earned money on instead of marketing. So this, we hope, is a good guide for people that are in the middle of the design process and just need a way to kind of issue spot what are the things that I need to be keeping track of and looking out for. And then it's a nice organization for if you ever do need to go consult with an attorney. It's kind of a nice organization process for laying out the facts for the attorney that you choose to deal with. And again, it's intended to be a resource. We have our copyright notice on this thing, but we'll circulate it after the fact via messages, or you can email us. And feel free to copy it, share it, do whatever you want with it. We came up with it as hopefully a help for the field. So that is this slide on the intellectual property worksheet. And that brings us to the end of the formal presentation time. We've got another 18 minutes that we signed up for. Our information is here on the slide as far as email and the general firm phone number that you can contact us at. This is the same slide set that we will go through in a similar presentation that we do on site at GenCon. That's tomorrow, Friday afternoon. That is in the Marriott. I didn't put that here because this is the same slide set for that as for this. However, we do a much shorter version of this with much more Q&A in a Saturday session that is in Crown Plaza. So if you are happening to be in Indianapolis this weekend, we will be there. Please say hello if you see us or come to one of our sessions. And as I mentioned earlier, I did record this part of the talk, and I'll turn that recording off here in a moment. We'll put that up on YouTube for everybody. But at this point, we can open it up to questions, whether in the chat or if you want to unmute and ask, basically fire away. We do have some supplemental slides we can go to if we dive into things like fair use that we can jump to, but otherwise, floor is open.
Okay, and so first of all, we have one question where on YouTube, Dave, maybe you could just put that in the chat, your YouTube handle.
Yep.
So everyone has that. And then we have a question from John, it looks like. John, go ahead.
Thanks, guys. Thank you so much for this panel. Can you guys hear me?
Yes.
Yeah.
Okay,
yes.
cool. Wasn't sure. You mentioned non-disclosure agreements. I've heard a lot of conflicting things about non-disclosure agreements. If I'm going to have a friend of mine play test or beta read my my RPG, or if I'm going to send it to someone to have it professionally edited, do I need a non-disclosure agreement in that case?
So, for maximum, protection in terms of preventing someone or trying to prevent someone from disclosing it to other people, then, ideally, yes, you would have an agreement, non-disclosure agreement in place. If you are otherwise comfortable with the individuals you're working with and are, confident that they wouldn't disclose
Sure.
it just because you asked them to, then yeah, perhaps you can get away with not using an NDA. Some people aren't comfortable, signing them or using them generally. Some companies aren't comfortable signing them if they're working with, an unknown designer